adoption of Elena.
Hey, Sue, tell the chief. Tell the chief we have to move all of our stuff. We're just starting to go.
Mr. Palliser?
Yes, may it please the Court, Brian Pariser on behalf of the Department of Social Services. We're here today on the Department's application for further appellate review from the Appeals Court decision in adoption of Elena. And in that application, the Department submits and continues to submit today that the Appeals Court overstepped its role in second-guessing the trial court's assessment of the evidence and its exercise of discretion in regard to the termination of parental rights, specifically in this case. Contrary to my brother's argument, this case is not the adoption of Carlos' case. It is not in line with that case or cases of that nature. In this case, the trial court clearly found parental unfitness by clear and convincing evidence, and the appeals court implicitly affirmed that finding of unfitness when it expressly affirmed the grant of permanent custody to the department. We can assume that the appeals court is aware that permanent custody cannot be granted to the department without such a finding of unfitness. So there is clear evidence of parental unfitness, and that is based on a 15-year history of substance abuse, of exposing children to substance abuse, to drug addicts, to drug dealing in the home, to serious domestic violence. Yes.
Is any adoptive family in the picture here for the three youngest children?
I respectfully ask whether Your Honor is meaning currently or at the time of the record was created?
Yes.
At the time the record, well, the record changes over time because there were post-judgment motions. Initially, at the trial, there was a permanent home for Jessica, who was placed with her aunt. And the two oldest boys had a plan of recruitment that was submitted to the court. I think reference is made, though I don't think evidence was taken about it, but at some point there is argument on a motion for reconsideration. At that point, there are representations made that those children are being transferred into a pre-adoptive home or a permanent home has been identified.
Why was there such a rush to judgment in this case? It just seems strange to me because these cases usually drag on for a year or two and we have problems with how long they are. But here it seems just the opposite. Wouldn't it have been a better approach or a more rational approach for DSS to have sought to have the children, they were already under the aegis of care and protection, to have that continued for another year with visits with the mother, and then see what the status was with the mother?
Well, at the time that the court held trial, it was 9 months after the filing of the care and protection. I know the mother claims that seems to be a rush to judgment, but while the time standards certainly begin to kick into effect when the care and protection is filed, I think what the trial judge had before him was not merely 9 months since the care and protection was filed, but had a case that had been going on for years prior to that point. When you look at it in context of the length...
Correct me if I'm wrong. I thought that previous complaints had been dismissed.
There had been no previous care and protection matters. There had been 51A reports filed with the department.
Right, and they had been dismissed as not substantiated.
I think there was they had varying dispositions.
Okay.
But I think
there was still some open as well. It hadn't been either. Well, in any event, there were a number of 51As.
Yes.
And some of them were substantiated, but the individual agreed to accept services, and therefore those were dismissed. In one, she got a restraining order to keep the abusive person out of the house, and so therefore the complaint was dismissed. But they were all supported, as far as I can tell from the record, and maybe I'm wrong.
In one fashion or another, there are some that are supported or not supported as to a mother or as to a father.
Exactly.
But they all have supported allegations of neglect of the children in the home. But I think, to go back to Justice Cowan's question, the issue that the trial judge was dealing with was not merely a 9-month period from the filing of the care and protection, but was looking back on a history that spanned well over a decade. And that was a
No question there, no question. I mean, if the mother had continued on the way she was, no question. End of case, in my opinion. But here, where the mother had indicated at least some effort to change.
This was after her parental rights had been terminated and 2 other children, correct?
Well, those 2 older children, well, they were terminated at the same time. The trial concerned all 5 of the children.
Right.
Rights, actually, you are correct, Your Honor. The court, I believe, at the close of the trial did enter termination decrees as the oldest children and took the other 3 under advisement, if I'm
And that was
remembering
July in
correctly.
2002.
Yes, and the mother did not appeal the termination with respect to the 2 oldest.
I mean,
In fact, she concurred in it and tried to even waive her rights.
She had attempted to surrender the court.
She
did
didn't
not
want the
take
2
them.
older children, in any event. She did not want to have the 2 older children.
She did wish to sign a surrender that the trial
I
court did not
repeat
take.
my question, because the time that it's taken for this appeal, it's gone through the appeals court, it's come up here, I haven't figured out how long it was. My guess would be a year or 2. So if the judge had taken another 6 months or 9 months to decide this case, you'd be in a much stronger position one way or the other. One side would be on appeal, if there would even have been an appeal.
That is possible, depending on what would have happened in the legal process. But in any event, the fact that the judge decided to move this case to trial and to hold a trial within 9 months of the filing, and as I said, after a substantial history before him, was not reversible error. There are some judges that may have decided to take more time or not. There may have been parties that agreed to or not. But it cannot be said that holding a termination of trial in a 9-month time is reversible error.
I thought there was fairly compelling evidence that the timeline, 9 months, depending on the age of the children, and these are very young children, makes an enormous difference. I mean, it seems to me that we are confronted with what we are frequently confronted, namely a parent who is essentially a substance abuser. Those are very difficult conditions to overcome. And the question is how long the state can permit essentially the non-care of children to perpetuate while somebody attempts to overcome their substance abuse.
And I think that's correct. And in looking at that, while the court, I have no doubt that Judge Corbett had that in his mind when he moved the case to trial, but in looking at that, again, the conditions before the care and protection were filed were clearly relevant to the judge. If this was a mother who had just begun substance abuse at the filing, it might have been different. I don't know. But the fact that she had a documented history of untreated abuse and serious neglect of these children
Was something the judge could take into account.
He could clearly consider that in deciding when it was appropriate to hold a trial.
I assume the judge could also take into account the difficulty of placing older children for adoption. Correct?
Yes, though certainly with respect to the 3 children before the court today, at the time of trial, they were ages 5, 3, and 18 months, I believe.
Yes, and there's a difference between that and 7, 5, and 3.5 years.
That's correct. So in any event, there was compelling evidence for the judge to consider the amount of time that the children had been subjected to neglect in their lives with their mother, to consider her history of failing to address her own substance abuse, her own exposure to domestic violence, her subjecting her children to domestic violence, and her general neglect of the children's care. And all of this amounted unquestionably to clear and convincing evidence of her unfitness. It is not Carlos, as I said in the beginning, because with respect to the Carlos decision, this court said there must be credible evidence of a reasonable likelihood that the unfitness is temporary. In this case, the trial judge said in no uncertain terms at the end of his decision that that was not the case. He expressly said he could not be certain when, if ever, he could return the children to the mother's care, despite the fact that she had made some encouraging progress a matter of weeks before the trial commenced. That in light of her history and in light of the short duration and essentially the fact that her recovery was in its infancy, that he could ever be certain of when he could return the children. And in that regard, the fact that we were dealing with a 5, a 3-year-old child, an 18-month-old child, I would go back to Chief Justice Marshall's point and say, if there is uncertainty, that clearly is something that the judge can consider in deciding whether termination is appropriate or not. And if there is uncertainty, then he has clearly overcome the Carlos question of whether there's a likelihood of success, a likelihood of rectification of the situation.
Is the judge's finding that the bonds among the children were far stronger than the bonds between the children and the mother, supported by the evidence?
Yes. The judge makes a specific finding, and I forget exactly which one, but there's an enumerated finding that by the time the care and protection had been filed and the house was in a deplorable state, that at that point in time the mother had clearly abdicated her role as a parent and handed over that role to her oldest daughter. He makes several findings that, in essence...
No, I saw the findings. There's no claim that that is not supported by the evidence.
That's right.
And clearly the judge considered that when he was considering the best interest of the children. I mean, that wasn't the basis of his decision, but it was a factor.
It was a factor, and I would submit, as I wrote in the department's brief, contrary to my brother's argument, and contrary to the appeals court's decision, that was not the determinative factor in this case. If one looks at the entire decision of the trial court, it is only in a sentence or two at the end, after making this Carlos-type decision, that there's no likelihood of that this unfitness is temporary. And after making extensive findings around unfitness, at that point he says, and there's also a factor, essentially, of the sibling relationship that may be at issue here. The appeals court took that in its decision and it seems blew it out of proportion to the weight that was given by the trial judge. It was a factor. It was clearly not the determinative factor in the trial court's estimation. I see that my yellow light is on, and if there are no further questions, I would yield the rest of my time to counsel for the children.
Thank you, Mr. Puisa. Mr. O'Brien?
Good morning, Your Honors. May it please the Court, Attorney Gary O'Brien on behalf of the minor children, the 3 youngest children. I would, I guess, in follow-up to a couple of the Court's earlier questions, point out one of the other things that the trial judge had to consider, as well as the department had to consider, is that after the filing of the petition, for 5-6 months, mother was not participating in services, not visiting with the children. The court was faced with 3 very young children and needed to establish, as this court indicated in Nancy, some permanence, some stability, some permanent plan, and needed to move ahead with that. And so I would add that as an additional factor that the trial court and the department were considering in order to, in terms of the timeline of when things happen.
I take it that even when she began visiting them, at least on the 2 occasions that I recall reading about, on one she was high on drugs.
That's correct, Judge. And I believe also that she didn't enter into any services or a detox until I believe it was April 24th, approximately 5 weeks before the commencement of trial, despite the fact that when she was present in court in February of 2002, that she knew that the case was already scheduled for a termination trial. The second point that I would make is with regard to there was a motion to reconsider filed by Mom's counsel in this case, and I think in reading the trial court's comments from the bench at that time, he said, if I thought I was cavalier or I didn't really consider everything, consider a Carlos disposition or a permanent custody or other such disposition, then I perhaps would reconsider, but I really thought this through quite carefully. I gave it close attention, and I'm not going to reconsider my decision. And I think that gives real emphasis to what the trial judge was considering in terms of when he made this judgment.
Didn't the trial judge reopen the case and have take more evidence in October, or have I misread the record?
He did, Judge. In October, after
she completed the detox program.
And he took all that
Right.
into consideration, much like Carlos. And in Carlos, the trial judge took more evidence into consideration and then decided that that was compelling in order to not terminate parental rights at that instance. In this instance, the converse, in terms of the trial court and his considerable discretion, made the decision, reviewing everything, getting an update with regard to what had occurred over the following months, and still determined that there wasn't a compelling case, or there was a compelling case to terminate parental rights at that point.
Mr. McCarthy, may I ask you this? The appeals court seemed to have relied on its understanding that there was no showing, or not a specific showing, that the children's best interest required the termination of the relationship.
Well, Your Honor, I would point the court to Nancy, which specifically said that there isn't necessarily the need for that specific showing of that termination is in the best interest of the children.
No, I understand that, but my reading of the findings, even if the judge didn't use the magic words, the best interests of the children, I thought that there was evidence that in fact it was in the best interests of these children. And foremost among those was the judge's finding that this woman, probably with a great deal of difficulty, was handling her substance abuse problem, but that the suggestion that she could both do that and hold down a job and look after 3 young children, that she was too fragile to do that, and that you were placing the children at risk again, notwithstanding her considerable efforts to overcome her dependency on drugs.
Yes, Judge, I agree with that. I think the trial judge said that it was doubtful that would occur and that it was in the best interest. I think it can be, as Nancy said, inferred that the trial judge made the decision that it was in the best interest of the children to terminate.
Well, he clearly made that decision. He says it. But the question is whether there's evidence that would support it. And I think
I would submit that there certainly is overwhelming evidence that termination was in the best interest of the children.
Not with respect to this case in particular, but the appeals court said in quite broad language, a judge may not substantially base his decision to terminate parent rights on the bond between siblings and the theoretical possibility that sibling visitation would be forestalled without engaging in a thorough analysis of the relevant criteria. What do you think the appeals court, essentially the appeals court says the judge has to make specific findings concerning the harm the children would suffer if returned to the custody of the mother. What is your view with
regard to the bond, Your Honor?
I'm just looking at what the appeals court says. There's a very lengthy paragraph here.
And I'm not quite sure what I've looked at that paragraph. I'm not quite sure what the appeals court was discussing. I agree with counsel for the department that the issue with regard to the siblings was after and set to the side in terms of what the evidence was for termination. It was used as an additional point that would be serve the best interests of the children. I'm not sure specifically what evidence would needed to be addressed with regard to the bond and the sibling visitation issue, but I don't think it's central to this case. Perhaps I'm missing Your Honor's question. I don't quite understand.
There's a lengthy discussion by the appeals court of what it says the judge has done wrong here, and I was trying to understand what the basis for those very broad statements of the appeals court were.
Again, the only thing I think would be just with regard to the judge's consideration of the sibling contact and the fact that there was some evidence that the older siblings were in some ways the caretakers for the younger children, and that there was some bond there that would be of benefit to the younger children. But I don't think, again, it was a compelling part of the decision of the trial court.
Thank you.
My time is up. Thank you, Your Honor.
Mr. O'Brien. Mr. McCarthy?
Thank you, Your Honor. Attorney Robert McCarthy, Jr. for the mother. May it please the Court. First, Your Honors, my client did not have a 15-year history with the Department of Social Services. If you look at the evidence, prior to 2001, only 2 51A reports were filed regarding my client. As the appeals court correctly pointed out, one of those filed in 1997 was closed within 7 days.
That's because she got a restraining order to keep the abuser away from her children and herself.
It was unsupported for substance use, Your Honor.
But supported for domestic violence.
No, Your Honor, it was closed and unsupported totally. That's what the record says.
Okay, I thought the record said that it was closed because she had obtained a restraining order to keep the abuser out of the home.
Your Honor, I believe...
And how could that be unsupported?
That's what it said in the record, Your Honor. It was unsupported in 1997.
It's not how I read the record, but we'll go back and look at the record again.
In 1998, there was also a 51A report filed, and that was also closed.
After she accepted services from the Department of Social Services.
Yes, Your Honor. But again, that 51A was not filed due to substance use. And this case is
What was it filed due to?
It was filed due to other reasons. The mother needed services. However, this case is about substance use.
She has admitted in her own testimony that she'd been abusing drugs for a decade and a half. Her children, her oldest children, described in great detail the years of her use in the home, of her sales, of her bringing men into the home for sex, to get drugs. How can you say that this does not involve more than a decade of horrible conduct?
I can say it, Your Honor, because the Department's record doesn't reflect that. The Department's
the record at the trial reflected that.
But the Department of Social Services stands up here and tries to tell everybody here that there was a 15-year documented history of substance abuse, and that's not true. It is
well,
not
I don't
true
know what you mean by, I don't know, I didn't read what the Department was saying, that their records documented 15 years, other than the fact that their investigation revealed, largely through the testimony of your client and her children, that indeed the abuse of relationships had gone back to 1986 through all of her various boyfriends and husbands whom she had to throw out or had to get restraining orders against, and also her drug use. So the record of this case surely has a 15-year period of various forms of abuse.
Your Honor, the children were not removed from my client's custody until September of 2001.
And that's terrible, I suppose, but we start where we start. When finally she was taken away and locked up and left her children in the care of a man she'd met 2 weeks ago, and there were reports that caused the Department of Social Services to go to the home and find unbelievably deplorable conditions there, that's a shame and that's too bad. But that's where we start.
An April 2001 assessment by the Department of Social Services filed only months prior to the September 2001 filing. This petition showed, the Department's own record showed that my client was capable of taking care of her children in April of 2001.
Mr. McCarthy, I think one of the difficulties that courts face, and it is just a reality, or it seems to be a reality, that people who are unable to overcome substance addiction, which is a very difficult thing to overcome, when faced with a particularly dire consequence, of which losing one's children must surely be, may be able to overcome their addiction. I think the question before a trial judge is, at what further risk can we place children, whether or not one ascribes blame or has a view of the mother's conduct. And I think that that's what this judge attempted to do. And the difficulty I have is it's a judgment call. It's very difficult for us sitting as an appellate court without an opportunity to view and understand. And I think surely a judge has to take into account evidence of how long this has persisted, whether or not the Commonwealth has intervened in the family before the precise date.
Yes, Your Honor. The standard of proof is current unfitness and best interest of the children. My client was currently sober before, during, and after this trial.
And that is an admirable achievement on the part of your client, an admirable achievement.
Yes, and she entered into a substance use facility. It was an A-rated facility. It was licensed by the Department of Public Health. She graduated from that program. It was a 6-month program. The trial judge recognized that the mother was sober. The further hearing that was held in October of 2002, he took evidence that she had graduated from the program. She maintained her sobriety. She had attained her sobriety. She had aftercare programs in place. She had the support of her family. If the standard is current unfitness, my client had overcome that problem.
I take it that her testimony was that she would not be able to take custody of the children for at least a year. Or am I misreading the record again?
Your Honor, this proceeding went over a number of months. It started in June of 2002. There was a further hearing in October of 2002. The mother brought a couple of post-trial motions that were heard in 2003, February and March of 2003, and the department brought a motion to amend the findings in June of 2003. And those post-trial motions that were brought by the mother, the mother presented information anyway to the judge that her sobriety had continued.
Mr. McCarthy, as I understood, one of the judge's most powerful concerns was his view that if the children were returned to her custody, one of the issues here is where will these children be permanently? And so simply saying that somebody else is taking care of them, I think the judge is faced with, if they return to her custody, that the situation was sufficiently fragile that I'm now using the words that the judge did not use, that there would be a spiraling backwards, placing the children at risk again. Was the evidence to support that concern, what appears to have been a concern of the judge?
Your Honor, she entered into this program. She had a substance use problem. She overcame that problem. The standard is current unfitness. She was capable of taking care of her children at that point because she went through that program. She had a support system in place. She had therapy in place, and it was unfair not only to my client, but to the children who had a parent that was capable of taking care of them.
So you are arguing that the finding of unfitness was wrong?
Yes, Your Honor.
And that she was presently, at the time of trial, fit because she was in a detox program? That's your argument?
My argument is the trial took place over a number of months, Your Honor. At the end of the hearing that took place in October of 2002, she had graduated from a 6-month...
And at that point she was fit and the children should have been returned to her?
She was not unfit, Your Honor. She graduated from the program and she was capable of taking care of the children at that point.
And she testified to that they should be returned to me now?
She testified basically to that, except that she did not have housing, and she could have got the housing, Your Honor, if the goal had been changed back to reunification.
In other words,
when was it that
she was in a sort of lose-lose position? If she didn't have the children, she couldn't get the housing. If she didn't have the housing, she couldn't get the children.
Yes, Your Honor.
When was it that she testified that it would be a year before she would be
I think that was sometime at the beginning of, I don't know the exact date, but it was in the summer. The trial
was it in July?
Took place in the summertime. I don't know the exact date. And as far as the sibling visitation issue is the sibling issue about the visitation that the 2 oldest children would not be able to visit with the 3 youngest children because the 2 oldest children did not have a relationship with the mother, allegedly. I would point this court to the fact that in October of 2002 hearing that there was evidence presented that my client was visiting with all 5 of the children at that point. The appeals court correctly pointed out that the trial court didn't place proper emphasis on my client's right to be reunited with the children, and instead placed the emphasis on the rights of the 2 oldest children who are not part of this appeal and really do not have...
Well, was it the rights of the 2 oldest children or the best interests of the 3 younger children, that their bonds with their older siblings, who had been caring for them because your client was not, it would be in the best interest to ensure that those bonds continued? That's a little different, isn't it?
Your Honor, I don't agree that there's not evidence that the 2 older children were taking care of these children for their entire lives. My client did have some difficulty, obviously, when the case was filed in September of 2001, but I don't see any evidence that there was any strong bonds between. There was no expert testimony admitted into evidence regarding the 3 youngest children, any bond that they allegedly had with the 2 oldest children.
Mr. McCarthy, let me ask you this, and again, it's just a repetition, somewhat different of my earlier question. The impact of serious substance abuse, as appears to have been the case in the past with your client, has a huge impact on children, young children. And as I said, at a certain point, when confronted with something as overwhelming as losing one's children, that sometimes provokes people into a program where they are able to overcome their substance abuse. The trial judge was aware of all of that. The trial judge, in essence, had to make the best determination that the trial judge did about the best interests of these children. To what extent was it inappropriate for the trial judge to look at the long history of substance abuse, the considerable progress that your client had made in the face of losing her children, but having to predict something about the future? I mean, isn't the trial judge in a better position to weigh up?
Well, as far as the prognostication, Your Honor, that in order to terminate parental rights based upon prognostication, the evidence has to be more substantial. And our argument is before 2001, there's no documentary evidence indicating that my client even had a substance use problem. She overcame that substance use problem. So as far as the current use of my client...
No documented. Your client testified that she had been taking drugs since she was in high school and that she had been abusing drugs and selling drugs and of all sorts. I mean, I don't know what you mean by not documented. We didn't have any tests.
There's no evidence from the Department of Social Services. The 51A reports, their assessments, the documentary evidence that the Department of Social Services normally provide in a case like that was absent. But in order to terminate parental rights, Your Honor, regarding prognostication, my client was currently...
No, I understand that, but what the appeals court, and again I'm looking at the trial court and the appeals court, what the appeals court seems to be saying is, let's assume that we are satisfied that there's evidence in the record that she had a long history of abuse. You challenge that there is such evidence, and so we will make sure there is. But assuming that she had a long history of serious substance abuse and a comparatively short period of time when she was not abusing drugs, it can't be the case that if for the 1 month period, that a trial is ongoing, somebody is able to overcome their addiction, that a trial judge can't take into account not the prognostication, but to look at the overall status of somebody who's had a very serious addiction problem. I mean, addiction is very tough to overcome.
It is, Your Honor, and that's why in a lot of cases a client is unable to overcome a substance use issue like this. And you look at the Nancy case, which is cited by the appellees, where a father was given over 2 years in the hopes that he might rehabilitate. And in this case, my client wasn't given that amount of time, but did attend a substance use facility, did not relapse like the father and Nancy, did not deny that she had a problem like the father and Nancy, but admitted to that, and didn't go from program to program like the father and Nancy. She did what she had to do and did it well. And the appeals court corrected an injustice where my client was capable and willing to take care of her children. She overcame a serious and difficult problem, and she was quite able to take her children back. The appeals court's, the trial court's decision was based upon conjecture that it wasn't supported by the facts because my client was sober, and sibling visitation was an issue that the trial court actually was able to justify the decision to terminate parental rights because he wasn't sure whether or not the mother was going to be able to overcome the substance use problem, which she did.
Thank you, Mr. McCarthy. Your time is up. We'll take a short break.